Hey guys, happy Valentine's Day. Brian Felfel Law Group PLLC here with your Florida Law Weekly Case Update. What a better day than Valentine's Day to discuss some divorce cases, right? And of course, I got my pink shirt on because it's Valentine's Day. Only two cases this week, short and sweet. Another Valentine's Day reference. But both cases are interesting and they provide for some pretty critical legal points. So the first one is Silva versus Claffey. This is out of the fourth DCA. This has to do with what date does the trial court value a marital home in a divorce case. And so we all know that the date of classification, identification of the marital asset is the date of filing, but the court has discretion as to the valuation date. And so I always thought, and I'll be honest here, I always thought that the court usually and would err by valuing a property as of the date of the date of the petition filing if the result of the increase in value of the home was solely due to passive increase and not actually like active appreciation by one of the parties. Like if one of the parties made some improvements to the house during the divorce proceedings or something like that to actively appreciate the value of the home, I figured, well, okay, if there's nothing like that, then maybe the date of trial is a better date because both spouses should get to enjoy the passive appreciation. So according to the fourth DCA, I'm wrong, and that's fine, because not only is it just active appreciation by one of the spouses actually like doing something to improve the value of the property, it's also continued ownership of that property. So let's say, for example, exactly what happened in this case, one of the spouses moves out of the marital home, the other spouse continues to live there, continues to pay the mortgage as the divorce goes on. Well, if that spouse is the only one that's continuing to maintain the mortgage, paying all the expenses, then essentially they should be allowed to enjoy the appreciation and value of that home to the exclusion of the other spouse, and therefore the value should be the date of the filing of the divorce. So the other spouse wouldn't get to wouldn't get to enjoy that passive appreciation and value solely because the spouse in possession of the home was paying the mortgage and paying the expenses on the house. Now, to me, that's sort of like, I don't know if that's fair because, for example, in this case, the other spouse was paying other marital expenses. Like, for example, I think she was paying for the party's health insurance and things like that. Well, hey, something to consider. Maybe if you're in a case like that and you're the spouse that's out of the house, maybe just demand to continue to pay for the mortgage or pay for some sort of expenses associated with the house instead of other expenses, because unless you're actually participating in the continued ownership of the house, you're going to lose out on that extra passive appreciation. So interesting case to consider. Next case and last case is Justice Guerrero versus Justice. This is a case that deals with the UCCJEA. It was a battle of jurisdictions, depending on whether it was Tennessee or Florida. Apparently, the parties had some sort of house in Key West, or the father was staying at a house in Key West, sometimes with a child. Bottom line is, court in Tennessee adjudicated a motion to dismiss and found that the court in Tennessee has jurisdiction under the UCCJEA. So it denied the father's motion to dismiss in Tennessee. Tennessee is keeping the case. Court here in Florida didn't really hold a hearing on it, but instead held a conference, which is, the court has the ability under the UCCJEA to hold a telephone conference with the court in Tennessee, which apparently that happened. Now, the problem was the court here did not notify or provide sufficient notice that they were going to have that telephone conference and allow the parties to participate and make arguments or present facts. So because the trial court here did not provide the notice and allow the parties to participate in that conference, that was reversible error. So you got to make sure that if you're asking the judge, hey, hold a phone conference with a foreign court to determine, who's got jurisdiction under UCCJEA, make sure that the parties are provided sufficient notice so that they can participate in that phone conference, because otherwise it'll get reversed on appeal. All right, guys. Well, happy Valentine's Day to everybody. I hope you all have a lovely day and take care.